The question is, can you buy land in the name of your underage child? And will the purchase of that land or property be valid? The answer to that is what we want to address in this video. A lot of parents buy property, land, buildings, all sorts of property in the name of their child or children. I know people do this with the hope of securing the future of the children so that when they are no more, family members or friends or exploiters will not come to take what you have suffered to work for, leaving your children with nothing. And when you do this, you are doing it to protect your children. But the question is, what you have done, is it right in the eyes of the law? The answer is no. I will still tell you how to go about this, so please follow me on this. Now, when you buy a property, land in the name of a child, that purchase is invalid. The Land Use Act stipulates that anybody below the age of 21 cannot acquire land. And the Child Rights Act also provides that anybody below the age of 18 is a child and is not capable of entering any valid agreement or contract. So you see, once you have purchased the property in the name of a child that is underage, the purchase document, the agreement will read the name of the child as the purchaser. Then who signs it? A child's signature is invalid. If the child's signature is there, the document is already invalid. Then if it's the child's name that is there as the buyer and your own signature is there as the person who bought, so you can see there is contradiction. The owner of the property is different from the person who signed the agreement. Now, if you purchase this property from a seller who understands this rule very well, that seller can still sell that same property to another buyer. Then if you start going to court to claim that the land you purchased or the property you purchased has been sold to someone else and you want to claim it back, or you want the court to give an order for the person to leave your land, the question is, are you the owner of that land or property? Is your name on the title document? No. The person whose name is on the title document is an underage child that is not capable of entering any valid agreement. So that sale will be declared invalid. You might end up losing your money because you now need to start chasing the seller to recover your money, because the child cannot enter any valid agreement. A child cannot. The only way a child can acquire property in Nigeria is through a guardian. And meaning that if you're buying the property, you're not buying that property in the child's name. You will buy the property in the name of an adult and stating the fact that the adult will hold on to this property for the child until the child reaches the age of 21. Meaning, from whatever age the child is, if the child was 5 years at the time you did this, up until the age of 21, that guardian that you have appointed will be the person that will be taking all decisions concerning that land and property. The child cannot decide. And if the guardian is not you, or you are no more tomorrow, and the guardian is somebody who is not so good a person, that guardian can sell that property and take away the proceeds of the sale. And at the end, the child you're trying to protect will be left with nothing. The only other way a child can have property is through inheritance. If you will the property to the child, that is the only way an underage child can have property. But an underage child cannot purchase. The document to the purchase must not have the name of an underage child. How will you protect the interest of your children to ensure that they have access to your property when you are no more? These are the two ways you can do this. The first way to do this is to write a will. Purchase the property in your own name. When you are done purchasing the property in your own name, you will write a will. Writing a will does not mean you will go tomorrow. No. Writing a will is the best way to give your child or children the property you want them to have. Write a will specifying the fact that this property will go to your child if you are no more. That way, when you are no more, your child will automatically have possession of that property. Whether they are underage or not, it does not matter. The child will have possession. They can have possession through inheritance. Inheritance is the only way an underage child can have possession of a property, but not through purchase. The other way you can give your child ownership of property is by purchasing that property in your name. Now, when your child has reached the age of 21, you will prepare a deed of gift and gift this property to your child. Transfer the documents to your child. That way, that property has become that of your child and nobody can take that property from your child. So please, if you're buying property in the name of your child, or if you have bought, go and correct the documents to the property, because if somebody hijack those property tomorrow, you cannot get legal redress, because the documents are not in your name, they are in the name of an underage child. So please learn this so you don't make a mistake because you're trying to protect the interest of your children. Don't purchase property in the name of an underage child. Purchase the property in your name and write a will bequeathing that property to your child. Or if God keeps you alive till the child clocks 21, prepare a deed of gift and transfer that property to your child. Don't purchase in the name of an underage child.